Hey friends, hope everybody's well and safe and practicing good social distancing in this time of the coronavirus, COVID-19. It's Josh Goldstein, your favorite immigration lawyer. I'm coming to you today from my home office. I'm working from home, practicing social distancing myself. I am a virtual lawyer, so to speak, now. And today I'm talking about domicile. Domicile is an incredibly important concept and legal principle that you need to know about if you have any kind of a family-based immigration case that's going through a consulate. If you don't know me, I'm an immigration lawyer. I file cases, all sorts of immigration cases, but I'm particularly interested in helping people whose visas have been delayed by consulates, especially administrative processing and 221G. I sue consulates around the world to help people who are stuck in administrative processing. I file writ of mandamus lawsuits against consulates. And the issue came up in a Facebook group called Visa Delay 221G and Administrative Processing Solutions. And I want to explain to you what the question is, and I want to answer it so that you understand exactly what the domicile issue is, because this is going to trip up a lot of people. So here, this is from Rashid, our friend Rashid. He says, hey, I need your help. My sister's visa, F2B, is stuck in administrative processing for the last 7 months. My mother sponsored her, and they asked my mother for proof of domicile, but she doesn't have an active bank account, investment, job. She only has her ID and voter registration. What should we do next? So I want to explain to you what is happening here and how you can tackle it. First of all, in any family-based immigration case, the petitioner, the person who files the I-130 visa petition, must be domiciled in the United States. They must live in the United States. But what happens in a lot of cases is people file the I-130 as petitioners, and then they move back to their home country to live with their family members who are waiting for their visas. And then the consulate questions whether they've met the domicile requirements. So how do you win? How do you get out of this? How do you respond to the consulate? Well, let's take a look at the Foreign Affairs Manual, what they call the FAM. And I want to explain to you exactly what the FAM says. So it says here, for the purposes of INA 213, this has to do with the affidavit of support. It says the sponsor must be domiciled in any of the 50 states of the United States, et cetera, et cetera. Domicile means that the place where the sponsor has his or her principal residence with the intention to maintain that residence for the foreseeable future. And this is a critical part here in number 2. It says a permanent resident, a green card holder living abroad temporarily, is considered to have domicile in the United States if he or she has applied for and obtained the preservation of residence under 2 and 6. So that's temporary proof of abroad. Establishing domicile. Let's go through this. A petitioner who is unable to demonstrate that that he or she is domiciled in the United States and wishes to qualify as a sponsor must demonstrate that he or she has already taken up physical residence in the United States, or that she has taken concrete steps to establish domicile and will do so concurrently with the applicant no later than the intending date of admission for adjustment. So that means that in order to qualify for domicile, you have to have either you're already living in the US, or once the visa is issued to the beneficiary, you plan to return with the beneficiary. So how do you do that? How do you convince the consulate that you either live in the United States or that you plan to move there? Well, the Foreign Affairs Manual explains to you how you do that. This is in part 2. So it says here, evidence that the sponsor has established a domicile in the United States and is either physically residing there or intends to do so concurrently may include the following: opening a bank account, transferring funds to the United States, making investments in the United States, seeking employment in the United States, registering children in school in the United States, applying for a social security number, voting in local elections. So these are some ways you could do it. But there are other ways. It says may include, but that's not the only way. You could use photos. You could use medical records, financial records, anything you can, insurance, anything that you can do to show that you've been in the United States, or that you have been living in the United States, or that you intend to move to the United States. We often include things Like, let's say that you have a husband who's applied for his wife. His wife is in the foreign country, and she goes to the foreign country to live with her spouse while the case is pending. What she might include is proof that you've moved to the United States, or that you plan to move to the United States, that you have an apartment, you want to show a lease, you want to show a driver's license, proof that you own real estate, that you have a car, that you have car insurance, that you file taxes in the United States as a resident, that you work in the United States. All these sorts of things, or that you've applied for a job, or that you have a job. All these sorts of things will help you crush this issue. And this issue is not a small one. This is a big deal. If you don't meet the domicile requirement, your case is going to be denied. So you really have to take it seriously. You have to document it really, really thoroughly. And that's what I have to say about domicile. If you have questions about domicile, leave them in the comments below, or message me, or if there's anything else I can do to help you with this issue or any other issue, please let me know. I'm here to help. Stay safe, be well, keep fighting for your immigration goals, and I'll see you in the next video. Thanks.